We are talking about this morning's big ruling from SCOTUS. So the justices, in a 6-3 vote, held that gay, lesbian, bisexual, and transgender people are protected from job discrimination under existing civil rights laws. The decision for the court was authored unexpectedly by Justice Neil Gorsuch, who was joined by Chief Justice John Roberts and also the former liberal justices, Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan, in a ruling that Gorsuch described as clear. So in his ruling, Justice Gorsuch wrote that sex discrimination in the workplace, which is banned by Title VII of the Civil Rights Act of 1964, includes discrimination against gay and trans workers. As Gorsuch put it, and I'll quote, "It is impossible to discriminate against a person for being homosexual or transgender without discriminating against the individual based on sex." So 3 justices disagreed with today's ruling: Samuel Alito, Clarence Thomas, and Brett Kavanaugh. For some insights on what happened this morning and what led up to it, we are joined today by Chris Geidner, Senior Advisor for Law and Policy at the Justice Collaborative, who has covered the past decade of big Supreme Court rulings on LGBT issues, and Leah Littman, Assistant Professor at the University of Michigan School of Law and co-host of the Strict Scrutiny podcast. Welcome, both of you. I'd like to start with Chris. Chris, can you talk to us a little bit about just like what happened today? Tell us what went down.
Yeah, so this ruling was sort of, in some ways, a long time coming. And what we had was an overwhelming majority, 6-3, this wasn't a 5-4 decision, saying basically that Title VII of the Civil Rights Act of 1964, when it banned sex discrimination, that what that did was ban sex discrimination, all things that are discrimination but for sex. If the person's, were it not for sex, the employment action would have turned out differently. And what Neil Gorsuch did was looked at that very simply in the quote that you read in the introduction, that like there just is no way of discriminating against somebody who's transgender without at base discriminating against them based on their sex as assigned at birth versus the sex that they present and perceive themselves as. And then the same thing when it comes to sexual orientation. If you are refusing to hire somebody because they are a lesbian and you refuse to hire them because they're a lesbian, and if they have a partner who is a woman, then if they were straight, they would have a partner who's a man. And so, but for the sex of their partner, but for the sex of who they are wanting to have relationships with, they would not be discriminated against. And he basically just went through the way that was handled, the way that people, employers in all 3 of these cases, the employer said, if it weren't for the fact that the person were gay, if it weren't for the fact that the person was transgender, I wouldn't have fired them. And so Gorsuch was like, this is very clear, and that's how they ruled.
So just for dum-dums like me, if I'm a woman and I have a wife and I get fired because of it, I'm being fired because I'm a woman. If I were a man with a wife, I wouldn't be fired. That's what you're saying.
Yeah, no, that's exactly right. And that analogy, or that has some analogies to the context of discrimination on the basis of race, where the Supreme Court has held that laws prohibiting interracial discrimination are discriminating on the basis of race, because you are treating someone differently dependent on, the race you assign to them, and the race of their spouse. And so this is partially the case law that the plaintiffs in these cases and the court majority drew upon. Justice Alito was in the dissent, and he tries to kind of distinguish this example, but, those cases, I think, provide a clear example of the kind of reasoning that Justice Gorsuch relied on that Chris was just explaining.
Professor Lippman, let's dig in with you on the reasoning here. So what led Justice Gorsuch and the Chief Justice, like we kind of get what got the liberals here, but what led the Chief Justice and Justice Gorsuch to this outcome?
Well, I think it was actually the same thing that also led the liberals to this outcome. And that is an interpretive methodology, textualism, the idea that we interpret statutes according to the meaning of the words that Congress uses, the meaning that the legislature uses. Justice Kagan, I believe, in her confirmation hearing said, we are all textualists now. And in a lot of ways, this opinion is indicative of that, because even the dissenting opinions, but clearly the majority, went out of their way to say, we are committed to the idea that the task at hand is for us to interpret the words that Congress enacted into law. Justice Gorsuch's majority opinion opens with this idea that when the express terms of a statute give us one answer and extra textual considerations suggest another, it's no contest. The text always wins. And he comes back to this idea throughout the opinion. The idea that discrimination on the basis of sex, that phrase and those words encompass discrimination on the basis of sexual orientation, or what Chris was explaining earlier, you can't discriminate against an individual who is gay, bisexual, lesbian, or transgender without taking account of their sex, has been an idea that numerous academics and commentators and practitioners have really been suggesting for a long time. In fact, this was one of the arguments that the plaintiffs in the marriage equality cases, Obergefell versus Hodges, advanced. This is an argument that academics writing about Title VII, this Civil Rights Act statute, have been arguing for a really long time. Katie Iyer at Rutgers or Bill Eskridge at Yale. So the idea that the clear text, the words discrimination on the basis of sex entail treating someone differently based on their sexual orientation or gender identity, that methodology is what I think led Justice Gorsuch and then also the Chief to the conclusion in this case.
So, Chris, you've been covering the court for 10 years on these issues. And I was just hoping you could tell us, like, how did we get here? Where did these cases come from? Do we have?
Yeah, I think it's interesting when you look at what happened today, even in the course of what Leah was just talking about when Gorsuch is explaining basically why the dissenters are wrong. He goes through and he says like Justice Alito is talking about what was in the original mind of the people who passed the Civil Rights Act of 1964. And he points out it's not just academics who started in the past few years. It's not just cases in the past few years. He points to the fact that there were people in the immediate aftermath of the passage of the Civil Rights Act of 64 who were suing and saying that this sex discrimination ban also included protections for gay people. And so what sort of we've seen happen at the court over the past decade, and really this started, I mean, remember, you had the Civil Rights Act of 1964, and then in the 80s, the Supreme Court heard a case, Bowers versus Hardwick, and they ruled that you could criminalize same-sex sexual behavior. You could criminalize sodomy between two men. And it wasn't until Lawrence in 2003 that they reversed that. And once they reversed that, you had this sort of like disconnect that became much more clear when you got to Obergefell and you had marriage rulings that like Pete Williams said from the front of the Supreme Court today, that you had this situation where if this ruling hadn't been how it came out today, you would be able to be married on Sunday and fired on Monday. And the court, I mean, and I think what you saw Gorsuch and probably, although we got no words from the Chief today, the Chief sort of struggle with is how do you gel with those two? How do you find that there's a constitutional right to marry, and yet we have this plain language of what sex is and how, but for your sex, you would be treated differently, that we could argue that doesn't provide that basic workplace protection that they found today.
So Professor Lippman, I mean, it sounds to me just culturally like this is a conclusion that feels very much in line with where we are culturally in the United States as a whole at this point. So why are conservatives so mad at Gorsuch, and why is Justice Alito so angry?
It's sometimes hard to tell why people are so angry, but in the immediate aftermath of the decision, numerous conservative legal commentators, ranging from the Judicial Crisis Network to writers at the Federalist to elsewhere, were decrying, Justice Gorsuch's betrayal, and declared this a crisis moment for conservatives and for the right. And there has always been this kind of fig leaf or really disconnect when we talk about methodologies, like how do you interpret the Constitution or how do you interpret statute, and we talk about originalism or textualism, and conservatives will say, well, these methodologies are separate and apart from any of the results that they lead to, right? And this is kind of an uncomfortable example where some people think, well, no, right? These methodologies are really supposed to lead you to socially conservative results. I think that is part of the disconnect that is happening and part of the anger at Justice Gorsuch in the wake of these decisions. Some of this anger has been going back to, there were even rumors coming out from the court that Justice Gorsuch had initially voted with the plaintiffs in these cases. And when those rumors came out, which by the way is super rare, as Chris can attest to, as someone who's covered the report or covered the court for a decade, conservatives were immediately saying, well, this would be a huge, betrayal and departure for Justice Gorsuch. But I think as his opinion makes clear, and as he made clear from argument, it's not like he was ruling for the plaintiffs in these cases because he thought, well, yes, as in 2020, this is where the United States is culturally. He's doing so because he thinks it is impossible to discriminate against someone on the basis of sexual orientation or gender identity without taking account of sex, and that the statute as written doesn't care about whether you're treating all men differently or worse than all women. What it cares about is if you are doing something that is remotely conscious or influenced by an individual's sex. As to why Justice Alito is so angry, I think he has kind of a simmering rage that kind of gets us off at different points or things. But here, I think that there's a real possibility that this opinion might not have always come out this way. This opinion was from the October sitting. Justice Gorsuch has two opinions from that sitting. That is pretty rare, especially because several justices who are more senior to him, including the Chief Justice and Justice Ginsburg, have zero opinions whatsoever. So it's possible that there was some fluidity in who had the opinions and how these cases were going to come out that is contributing to some of Justice Alito's dissatisfaction with the outcome in this case.
I'd be curious if either one of you can talk a little bit about a criticism, or rather, I'm not sure if it's really a criticism or an alarm that's being raised about the nature of Justice Gorsuch's decision here, saying that it lays the groundwork for an abandonment of Chevron deference, and basically educating our viewers a little bit on what that means, and if there are any things that people who are progressive in their ideology should be concerned about built in as quote unquote Trojan horses into the ruling.
I'm happy to share some thoughts. I don't know, Chris, if you want to. Oh, okay, so I can start. I guess two concerns that I saw from reading the opinion. One is just the extremely muscular commitment to textualism that Justice Gorsuch had. I think some people are wary about subscribing to the idea that textualism, the idea that you just look at the words in the statute and can decipher their meaning, is necessarily what is capable of resolving all of the court's cases. And in fact, some people think that you should consider things like, well, what are the practical consequences of this decision? What was the problem that Congress had in mind when it enacted this statute? Because sometimes that can shed light on how to interpret a statute. So the muscular commitment to textualism, I think, raised some red flags to people who are skeptical of embracing that methodology as a solution to judicial discretion. I think the second concern that some people had with the decision is the decision brackets the possibility that there could be religious liberty claims by employers or other entities who are subject to non-discrimination provisions, but have religious objections to being subject to those provisions. And in particular, Justice Gorsuch's majority opinion suggests that the Religious Freedom Restoration Act another federal statute might be a super statute that prevents applying Title VII to employers with religious objections. Now, as he notes, these employers, the plaintiffs or the defendants in these cases, they themselves either didn't have religious objections or they didn't raise their religious liberty arguments in the court. So he left that to another day. But it's very possible that a different majority at the Supreme Court would say, well, you can't apply these non-discrimination statutes to employers who harbor religious objections to the non-discrimination protections. And those were kind of the two Trojan horses that I saw in the opinion, but Chris might have others.
Yeah, I mean, I think that those are both right. The other area where Justice Gorsuch did mention specifically along with the religious freedom aspect was the fact of sort of he gave like 2 paragraphs of what we're not resolving in this case. And the one was the religious freedom. The other one was this question of bathrooms and locker rooms, which just weren't at issue in this case. And that obviously was something that took up a lot of time at the arguments, but the sort of, he limited it as to what the court actually said and what was before the parties, the fact that like the religious freedom claim hadn't been brought, the fact that there weren't restroom issues, there weren't locker room issues, but it was also, it was, as he said, a very clear ruling. And I think when we look at things like the fact that the Trump administration just like announced this reversal on Section 1557 of the Healthcare Act, the ACA, that sort of pulled back protections for transgender people. It's very hard with Gorsuch's ruling today to see how that could ever be upheld as a permissible reading of the statute because it uses the same language of sex.
I'm also wondering, and you touched on this a minute ago, Professor Lippman, but this is a question for both of you. Justice Alito is really mad at Justice Gorsuch for betraying Justice Scalia. Justice Scalia, of course, being perhaps the most famous textualist justice, and famous not only for his opinions in their very fun prose style, but also for his extensive discourse and sort of explanation of the value of this type of interpretation. So where would Scalia have been on this, and why is Alito so mad here about Scalia in particular?
So,
Professor Lippman, I'm going to kick it to you.
Okay, sorry. So where would Justice Scalia have been on this? I think the answer might depend a little bit on whether you are thinking about Justice Scalia when he initially came onto the court, or maybe Justice Scalia in the last 5 to 10 years of his career. I think Justice Scalia as a textualist, as the principal proponent of, an advocate and defender of textualism on the court, he would have been with Justice Gorsuch in the majority. I think that Justice Gorsuch's opinion reflects a better application of textualism in brushing to the side all of the kind of policy consequences or attempts to smuggle in what the drafters of the Civil Rights Act were thinking about. And I think it just represents a better application of the methodology. And in that sense, I think Justice Scalia would have been with him. But I think that in the last 5 to 7 years of his career, my co-host Kate Shaw has suggested that maybe Justice Scalia became a slightly different Justice Scalia that departed on maybe a few more occasions from the interpretive principles that he was so committed to. And in that sense, perhaps Justice Scalia would have been in dissent, but I don't think it's fair or right for Justice Scalia to say that Justice Gorsuch is perverting Justice Scalia's methodology. But as to whether Justice Scalia would have been with Justice Alito or Justice Gorsuch, I think it depends on whether he would have been willing to follow his own methodology as Justice Gorsuch was willing to do here.
It's pretty extreme to call someone a textualist pirate. I mean, he literally called the guy a pirate. Right, so
Yeah, he said they're waving the textualist flag, but if you look closely, it's a pirate ship that's smuggling in this forbidden, policy-oriented pirate booty. Was basically
smuggling in forbidden equality. All right, so looking forward, this is a question for both of you. I'd love for you to walk us through the implications of this decision, where we go from here. You've talked a little bit about the impact this decision could have on other statutes and cases, but what about other decisions this term or other things that are kind of percolating in the Supreme Court hopper?
Yeah, I mean, I think that the question for, I mean, the fact that Alito basically attached a how-to guide, he attached this appendix of all of the ways in which sex figures into federal law, it was a weird move when you lost the case, because it really was sort of a how-to guide for lawyers across the country, and certainly for the sort of national organizations that already have these cases in process, because again, this was a 6-3 ruling. This wasn't that close, and to be on that losing of a side, and to do that, I think it is. It was a weird move. I mean, it was Matt Alito. And I think going forward, I think this does put a lot of solid groundwork in place for how the definition of sex should be applied, and that it continues. This wasn't new. I mean, if you go back and read the decisions, Price Waterhouse that expanded sexual harassment, if you look at On Call, which was from Justice Scalia and extended sexual harassment to same-sex sexual harassment. I mean, some of the language in that decision by Scalia basically says this is a broad remedial statute, and that's how we interpret civil rights statutes. And so I think in that sense, this is a very good ruling, as lawyers across the country are looking not just at federal statutes, but also state statutes. This gives them more language from from Neil Gorsuch. So they're going to be able to go to court and say, look, this is what Neil Gorsuch, this is what the Chief Justice said. This is not some radical left position. And I think that does give a lot more oomph to those arguments that a lot of people felt were very strong already.
Go ahead, Professor Lippman.
Oh, so I was just going to say, in addition to the appendix for future litigation that Justice Alito provided the plaintiffs, as Chris noted, it's also possible that this signals the likely outcome of some cases that are currently before the court, like McGirt versus Oklahoma, about whether Oklahoma can prosecute members of the Creek Nation on lands that previously fell within the terms of the Creeks Treaty with the United States. I think that Justice Gorsuch's clear commitment to textualism and brushing aside extra textual considerations suggests that the defendant might win in McGirt. I think it's also possible that the language in this case could affect other Civil Rights Act cases outside of sex discrimination or discrimination on the basis of sexual orientation or gender identity. Justice Gorsuch's language about what the causation standard is in non-discrimination cases, that it's a but-for causation, it's okay to have multiple causes, that doesn't mean that sex or race didn't affect it. I think that will be useful to non-discrimination plaintiffs. I think it's also possible that this case could have reverberations in the constitutional sphere. Is discrimination on the basis of sexual orientation or gender identity now subject to intermediate scrutiny under the Constitution because it constitutes discrimination on the basis of sex, which the court has said triggers heightened scrutiny under the Equal Protection Clause. So I think it's, those are possible avenues and implications for this decision that we'll kind of be waiting to see.
Those are fascinating possible implications. Last question, and then I will release you both back into the conversation that I'm sure we'll be brewing about this all day. But there's been so much talk about the Federalist Society's role in creating judges and in grooming people to be, in line with a particular ideology, and then assisting them in obtaining positions of great judicial power. I think we're seeing a bit of a breathless reaction today from folks saying that Justice Gorsuch's decision today proves that the Federalist Society experiment is over and that this doesn't work, and that there's that their efforts to put conservative people into these positions of great power have been for naught. Can either of you talk a little bit about whether those reactions are premature or justified?
Slow your roll. The Federalist Society is not a great disaster that we should declare their experiment is over. My goodness, let's consider some of the cases whose outcome we are still waiting. My guess is deferred action for childhood arrivals. The Federalist Society is not going to be saying, oh, well, Justice Kavanaugh and Justice Gorsuch betrayed us. We are also waiting on the religious exemption cases under the Affordable Care Act. We're waiting on Espinoza versus Montana Department of Revenue about school funding under the Montana Constitution. We are waiting on religious exemption cases for other civil rights non-discrimination statutes. We are waiting on the presidential immunity cases. We are waiting on the abortion case, June Medical. We are waiting on the constitutionality of the Consumer Financial Protection Bureau. And I would be shocked if many or perhaps any of these cases involve departures of justices who were selected in part through the Federalist Society process. So I would say, do not declare this experiment a failure, certainly not yet.
Slow your roll is almost always good advice, I've found. Well, Professor Lippman and Chris Geidner, I would like to thank you both so much for joining us, for helping us understand what has happened here today. Thank you for your scholarship and for your long history of telling these stories. And this has been The Briefing, and we will see you tomorrow.